Donald Trump is trolling Jack Smith, the Department of Justice, on True Social. And this one is catching a lot of people by surprise. And we can parse through it. But he says, the latest fake case brought by crooked Joe Biden and deranged Jack Smith will hopefully be moved to an impartial venue, such as the politically unbiased nearby state of West Virginia. Impossible to get a fair trial in Washington, D.C., which is over 95% anti-Trump, and for which I have called for a federal takeover in order to bring our capital back to greatness. It is now a high crime embarrassment to our nation and indeed the world. This indictment is all about election interference. I have called for a federal takeover. So this is an interesting little turn of phrase, given the fact that there's a whole bunch of hysterical Democrats who already think that Trump tried to cause a federal takeover of some variety in Washington, D.C. before. Like, you know, they call it an insurrection. What's another word for insurrection? I don't know, takeover? They said like Trump wanted to take over the country by leading an insurrection. It's like literally the same word almost. But we see what he's saying. I think he's saying a federal takeover of the municipality, right? The feds come in and take over the municipality affairs of D.C. because the municipality can't handle their own affairs. It's crap all over the place. Excuse me. You know, it's just a dump is what he said when he was there. So a federal takeover of the municipality peacefully, civilly, legally, lawfully, patriotically, you know, all the things. But when you read it at first glance, you hear that word federal takeover and you go, oh, okay. And so that's causing a lot of people to raise their eyebrows. And the language, I think, is very intentional. Now, I'm going to go through several Trump truth posts just to get an eye of what's happening. And all of these came out within the last 3 or 4 days. And this is, I think, very intentional, okay? He's talking about witnesses. He's talking about key people in this case. He's calling prosecutors by name. He's calling Mike Pence by name. And I'm going to go through this in a little bit about this conflict that exists because we now have two competing interests that are adversarial against one another. The criminal case process and the sanctity of that process and free speech and political speech and political life in America going head to head. So Trump is now calling out on the free speech world, Lil Mike Pence. In the criminal world, he's talking about a witness potentially. We're going to have a conflict. He says, wow, it's finally happened. Little Mike Pence, a man who was about to be ousted as governor until I came along. He's gone to the dark side. Says, I've never told a newly emboldened, not based on his 2% poll numbers, Pence to put me above the Constitution or that Mike was too honest. He's delusional. And now he wants to show he's a tough guy. I once read a major magazine article on Mike. It said he was not a very good person. I was surprised, but the article was right. Sad. And I actually agree with this. I think that Mike Pence has been dishonest about this. I don't think that they were asking him to deviate from the Constitution at all. It was a different interpretation of the Constitution, but it was never to put Trump above the Constitution. That was a failing campaign's political slogan to deal with a problematic issue for them. He also said this one was more recently. See, I clipped all these this afternoon. He says, I never said anything bad or even slightly inappropriate to Lil Mike Pence. What I did do was make him, over the many people who wanted it, VP of the U.S. Disloyalty in politics is alive and well. He says, there is no way I can get a fair trial with the judge assigned, he says in quotes, to the ridiculous freedom of speech, fair elections case. Everybody knows this, and so does she. We will be immediately asking for recusal of this judge on very powerful grounds, and likewise, a change of venue out of D.C. We'll see how those go. Now he says he's talking about the prosecutor by name. Deranged Jack Smith and our highly partisan, very corrupt Department of Injustice could have brought this Biden opponent case years ago, but chose to wait and bring it right in the middle of my election campaign. No way. I hope you're watching, America. Our country's being destroyed. Make America great again. Now, if this was any other political candidate commenting on the Department of Justice or this criminal case, this would obviously clearly be free speech, right? Clearly political speech. The Department of Justice, the weaponization of the Department of Justice, is one of the most talked about issues in the whole country. I mean, almost every single Republican candidate is talking about it and being asked about it. Even Biden and the Democrats are being asked about it. Are you sure this is legitimate? I mean, it feels like every day we wake up, there's a new indictment after Hunter's laptop releases some more information. So it's clearly political speech. He just happens to be also the subject of one instance of the prosecution by the illegitimate entity known as the DOJ, in this case, the Biden administration. One and the same, this whole institution. He's got another one. No way I can get a fair trial or even close to a fair trial in DC. Many reasons for this, but just one is that I'm calling for a federal takeover of this filthy and crime-ridden embarrassment to our nation, where murders have shattered the all-time record. Other violent crimes have never been worse, and tourists have fled. The federal takeover, right, of Washington over the municipality of DC is very unpopular with potential area jurors, but necessary for safety, greatness, and for all the world to see. Using that language again. Federal takeover. All the insurrectionists, the hyperbolic, hystericals, they're out there. They're going, did you hear Trump is talking about a federal takeover? He's going to do it again. He's going to steal the podium again and break the clavicle of that Secret Service agent. If you go after me, I'm coming after you, says Trump. And this shows up in a government filing that they got real nervous about over the weekend, which we'll take a look at, which was the subject of the protective order. All this stuff they want to stop. Isn't it terrible, he said? Again, one after another. This is intentional. He just keeps going. Why not? It's his free speech. He's exercising it. Before a judge shuts you up, you better exercise it. You better use it hard. And then the judge can say, you can say this, but you can't say this. And this political topic you're allowed to talk about, but this political topic you're not allowed to talk about. Remember, this is not the classified documents case. This is the January 6th insurrection case. And if they are as serious as they say they are, and they have all of this monstrous evidence that's going to incriminate Trump and show us what a conspiracy this really was, we've got Stuart Rhodes and others going away to prison for 18 plus years. If this is all so bad, why are they trying to silence him at all? Or why are they trying to hide information from us? Let us see it all. Let's see all the evidence that they've got. But they're not wanting to do that. They're going to be filing stuff under seal, as we're going to see. But here he says, isn't it terrible that a political opponent can haphazardly charge you with fake crimes in the middle of your campaign in order to interfere with your time and message and money, costing him millions and millions of dollars? And there is nothing you can do to stop this travesty of justice. No, unless you control the DOJ. It used to be that we had at least somewhat ethical prosecutors who followed historical norms. But when Trump won, all that went out the window. They had 2.5 years to file, long before the campaign started. Another Russia hoax should not be allowed to happen. He said Biden and Garland filed bogus cases against me, so it becomes difficult for me to campaign. Nothing like this has ever happened before. That's right. Must be unconstitutional, right? But somehow we will win it all. Considering the fact that I had to fly to Washington, a filthy, dirty, falling apart, very unsafe DC today, and then I was then arrested by my political opponent who's losing badly to me. Despite all that, it was a pretty good day, says Trump. Meanwhile, Biden and his family steal millions. Look, and he's going here to the judge specifically now. I'm headed to DC to be arrested for protesting a crooked election. This is further back. Unfair venue, unfair judge. We are a nation in decline. And so that's when he was flying back. And you can see one right after the other. Long list of thoughts from Donald Trump, all highly political, highly protected until recently, political speech in America, where you could talk about elections, talk about your government, petition for a redress of grievances, and engage in free association and free expression. It's like First Amendment. But Trump also posted this. Now, the government wasn't happy about any of this. We're going to see their protective order in a minute. But he is calling out every single prosecutor in this new campaign ad. He says, welcome to the fraud squad.
How far will the most corrupt president in history go to keep Republicans from winning back the White House? Meet the cast of unscrupulous accomplices he's assembled to get Trump. Alvin Bragg, the radical liberal New York prosecutor who refuses to prosecute violent criminals. Jack Smith, who's made a career persecuting innocent Republican officials. Letitia James, the socialist who ran on the promise, I'll go after Trump. And Biden's newest lackey, Atlanta DA, Fani Willis.
Fannie.
So incompetent,
Biggest
on
Fannie
her
in
watch,
Georgia.
violent crimes have exploded. So tainted, Willis was thrown off one case for trying to prosecute a political opponent. So corrupt, Willis got caught hiding a relationship with a gang member she was prosecuting. So dishonest, Willis was accused of creating a fake subpoena. Welcome to the fraud squad.
The fraud squad,
Donald
baby.
J. Trump, and I approve this.
And you see who's right there, don't you? That's Jack Smith, man. So Alvin Bragg, Big Tishy, Letitia James. We've got Alvin Bragg, Jack Smith, and then you got Fannie, the biggest Fannie in Georgia, who is prosecuting all Donald Trump. So just one after another. Boom, boom, boom. And I think this is all very strategic, obviously, right? I actually think his lawyers are probably having conversations about this, saying this is a very interesting wedge issue that we're going to use and exploit massively. Here's why. Pretty big conflict here. We've got two camps. We have the free speech, political speech, campaign speech bucket, which is very strong, very powerful in this country. It's the First Amendment. We protect it at all costs, or used to. We also have something that is critical, which is also known as the presumption of innocence. So all of these things, we ask ourselves, is what Trump's saying, is that protected? Is that allowable? Which one of these things should matter more? Free speech, political speech, campaign speech, or the presumption of innocence on one side of this scale versus the other side of the scale, which is a conflict, which of course is the criminal process. And in the due process, the government is going to say, hey, we need a fair shake here. We need to bring our witnesses. We need to do our due diligence. We need to have our investigation without any interference from outside sources. And plus, Trump might injure our witnesses, or Trump might expose something that's going to jeopardize the rest of this case or whatever, right? And remember, this is not the classified documents case. So emails, other than protecting the witnesses and the identities of the witnesses, or which again, I don't even know why those should be secret if this is not a national secrets case. We've got some privacy rights and some attorney-client rights and, victims' rights and stuff like that, but we don't even know who if there are named victims or anything like that. So my point is, on the other side of this free speech, political speech, campaign speech arm, we have protecting the criminal process. Theoretically, we have protecting the traditional norms. Normally, we don't blast judges. We don't come out and say, the DC court is totally illegitimate, or that the U.S. Attorney's Office is full of a bunch of corrupt partisan hacks. Normally, people don't say those things. But today we do. Why? Because, the traditional norms have been shattered into 1,000 pieces. They initiated the prosecutions against Trump, not the other way around. So if they want to turn around and then suddenly say, hey, you guys are being mean to us. Don't say things that are harmful out in public. We're honorable prosecutors. Give me a break. You guys started this. You guys raided his house for crimes that are on a much lesser scale with a lot less defenses than people like Joe Biden. And you did it, and you've done it 4 times now, or about to do it 4 times. And same things with due process. Can you still have due process? Can the prosecutorial proceedings happen normally, even if Trump is speaking? What do you need these gag orders for, in other words? Well, it's to shut Trump up. It's to limit his defense. Weighed in totality, it's not even a close question. And when we think about this in the future, if we fast forward just briefly, let's say a judge does issue a protective order, does gag Trump in any case. How are they going to enforce it? Just fast forward. Trump is obviously going to break it. And what are they going to do? Haul him in? You violated our protective order. He's going to say, so what? You're an idiot. And this whole thing's corrupt anyways. She's going to go, oh, you violated it again. He's going to go, so what are you going to do about it? Put me in jail? Lock me up? They might try to do it. But this is now going directly head on into the issue. Trump is even talking about this on the campaign trail. It's not just on campaign ads. And I'm going to make the donation to the swear jar on this one. Earmuffs for the little ones at home from the former president. Content warning.
Every poll, we're kicking Biden's ass. And that's the problem. That's the problem. And if I wasn't, we wouldn't be under investigation by deranged Jack Smith. He's a deranged human being. You take a look at that face, you say, that guy is a sick man. There's something wrong with him. Somebody said, why don't you be nice to him? I said, yeah, wouldn't matter. This guy's a maniac. They gave me a maniac. They gave him the nicest man in the world. You know the boxes hoax, right? This guy's got 1,850 boxes, Lindsay. He's got boxes in China.
In China. Oh, Chinatown. He just keeps going on. So, all right, you get the point. Now, he's going after the prosecutors. He's going after deranged Jack Smith. He's going after the corrupt DC. He's talking about a federal takeover. It's just been a bonanza because he is he's testing the maximum boundaries of his political speech. We have 2 overlapping issues here. Criminal case, free speech. There is a dramatic intersection between the two, especially now that he's running for office. So the government flipped out about this, and they sent a motion for a protective order in to the judge, Judge Chutkan. And here is what it looked like. We've got both the request, the motion, and then the text of the proposed order. And here's what they said in response. 4-page filing. This one came out on Friday night. I believe that is what it was. That is, yes, Friday. Came out on Friday after Trump posted on Truth Social. Coming out of the District of Columbia, United States of America versus Donald Trump. This is Jack Smith, Biden's motion for protective order. It is Joe Biden, Merrick Garland, and Jack Smith trying to shut up Trump. It says the government stands ready immediately upon entry of a protective order in this case to give Trump discovery, to give him access to the case files. Discovery that the Trump team has stated that they needed in order to abide by the trial date and comply with the schedule. To allow the government to begin to produce this discovery, much of which includes sensitive and confidential information. And again, this is the January 6 case out of DC. Release it all. What's so sensitive and confidential about it? The government respectfully moves for an entry of the attached proposed protective order governing the disclosure of discovery by the parties. So we're going to give you this file only if you promise not to do the things with it that we give to you. And so they want Trump to have his say. So when he says, I've got all this evidence, this is just garbage, I can't talk about it. The court can, this is Jack Smith and Joe Biden's Merrick Garland writing, the court can and should enter it immediately just to allow the government to give them the files. And they say that we should just enter it right now because Trump can modify it anytime he wants if he objects to it. So I know this is a technical point, but it's very important. The government is asking the court to just do it. Judge, just do it. And if Trump complains about it, then he can undo it. He can ask you to undo it rather than saying, Judge, hear from the defense before you do it. And they're saying that the reason you should do it is because we're in a hurry and we have all of this discovery to give. So it's like we're outside knocking on the door. Judge, just let us drop it off here. And then if they don't like it, they can figure it out on the back end, which is obviously if you're a defendant, you're like, what? You guys are just making up decisions about this stuff without my input on this? What are you talking about? It's a ridiculous request. It's in terms of like, let's just call it professional courtesy. It's insane. Just do it. If they don't like it, they'll figure it out. It's just like, I'll install the TV right there. And if they don't like it, they'll call me back and we can move it later. Are you going to move it later? No, it's staying there. It's much harder to undo something than it is to do it right the first time, which is why they're doing this. So the government says on August 1st, a federal grand jury came back with 4 garbage charges. We already know what they are. I mean, don't really know much about them. You'll notice that of the 4 charges, no seditious conspiracy in there, which is embarrassing. If there are prosecutors on this case, you should just be embarrassed with yourself because you got the Oath Keepers and the Proud Boys with seditious conspiracy, but not even Trump. What a joke. You said he was the leader. Didn't even charge him. And he's out free, walking around. On August 2nd, the government sent a proposed protective order for Trump. Trump's lawyers substantively responded on August 4th, the day Friday, with a different proposed protective order that they say did not, in the government's estimation, protect numerous sensitive material categories. And we're all sitting here going, what kind of sensitive categories? All right, grand jury materials, like what? Okay, we don't need the identities, but why can't we just have the grand jury transcripts? What did you present to them? Release all the transcripts. This is a public case, literally involving a presidential candidate. We should have every single transcript should just be put on the website right now for us to read. Why is it sealed? We should see, in the interest of transparency for these Democrats, why can't we see the transcripts? Put them up. Why is the government trying to seal all this stuff? And they also have sealed search warrant affidavits. Okay, so I can see like, yeah, we don't want to see the pictures of somebody's house who got raided by Jack Smith's team. I'm all in favor of that. I don't want privacy violated or anything that is, birth dates and personal identifying information. None of that stuff should be publicized for us. But they can redact every single person on the grand jury and they can give us all the transcripts. The defense has the transcripts or we'll get access to the transcripts. So why can't we see it? Why can't we publish these things? They want it silent. The grand jury's already done. They've already presented. Okay, it's over, done and closed. He's been indicted. So why can't we see? Let us make sure the indictment was legitimate or not. And they also don't want us to see the search warrant affidavits, which are the written documents that the agents will sign, right? They'll fill out the thing. Hi, I'm FBI agent Loserville. I've been employed for, 2 months and here's my training, 3 weeks in academy, whatever. And I've executed this. I hate the president. All right. So they file this affidavit. Can we read that so that we can see whether or not it's legitimate? The same day the government is trying to seal that stuff up, the government drafted a new proposed protective order. So they send that over to Trump's team. They say, well, this doesn't include what we wanted to include. So they send another one back. Then they want to reach a compromise. They modeled it on one that Carl Nichols, which is another DC judge, that he modeled when he gave it to defense counsel, noting that the government wanted to file this one today. In response, Trump's team says they wanted to note that they did not have adequate time to confer. So Trump's team says we don't have enough time to sit down and go through all this stuff with you. So they just went to a competing court from a different defendant. Now, this is why these people are so nuts. They're going to keep trying to make this case as though Trump is just a regular, ordinary defendant. So I don't know what recent criminal case they got this from, whoever this is. Like they went, they're like, well, this sort of matches this outfit. This is a hat. We need a hat. This is a hat, right? Here's my question for the government. Was this person in the Judge Nichols case, was he a former president also running for the presidency? Answer, no, he wasn't, probably. So they needed more time to confer. So in other words, it's an invalid comparison. It's a ridiculous comparison. So the government says, this is Jack Smith, Joe Biden, Merrick Garland speaking. The government seeks to provide the defendant, Trump, with discovery as soon as possible because we want to go to trial now, including certain discovery to which Trump is not entitled to at this stage of the proceeding. The attached order would allow the government to do that while also protecting a large amount of sensitive and confidential material contained within the first prepared production that we'll send as soon as the court issues an order. Such materials include, but are not limited to, personally identifying information, which again, you can protect all of that. I'm fine with that. Rule 6 materials, subpoena returns, witness testimony. Okay, yeah, all of this I want. Subpoenas, witness testimony, exhibits presented to the grand jury, materials obtained through sealed search warrants. Why are they sealed? Case has been filed. Unseal them. Let us see them. Sealed orders obtained by the government's filter team, recordings, transcripts, interviews, related exhibits of witness interviews. Okay, and sensitive materials obtained from other government entities. Like what? There's no UFO files here. There's no classified documents here. Is it the tens of thousands of hours of Capitol Hill footage? What do they have? We'd like to see it all. Are they going to say it's because of security concerns? They say the court may, for good cause, enter a protective order governing or restricting discovery. Yes, we know they can. Here, good cause exists because the issuance of the government's proposed order would, look, expedite the flow of discovery in this case, which as a defendant, we don't give a crap about right now. Like, we're going to get the discovery one way or the other, but expediting it? Okay, nobody cares. We don't want this trial to happen before the election anyways. So that's not a benefit for us. What is a benefit is going through the time so that we can prepare to respond to protective order requests and things like that. It's not about speed. That's not a defense interest. Give Trump prompt access to a large portion of discovery that he ultimately will receive. Again, right, exactly my point. He's going to get it at some point. So expediting it is not a valid reason to just enter it and then have Trump respond, and to protect the highly sensitive categories of the materials described above. The government's proposed order is consistent with other orders commonly used by the district and is not overly restrictive. It allows Trump prompt and effective use of discovery materials in connection with his defense, meaning when they say this, it means his like literal criminal defense in the court of law, not outside the court of law, not in the court of public opinion. He can't talk about any of that stuff if he's limited by the order, including showing materials to witnesses who also agree to abide by the order's terms. So not only can Trump and his people not talk about it, but anybody he shows can't talk about it. All the proposed order seeks to prevent, here is what they say, look, the improper dissemination or the use of discovery materials, including to the public. Such a restriction is important because Trump has previously issued public statements in this case on social media, here it comes, about witnesses, judges, and attorneys, and others associated with legal matters pending against him. And in recent days, regarding this case, Trump has issued multiple posts that we went through, either specifically or by implication, including the following, which he posted just hours ago. All right, so you've got some DOJ obsessives. They've been salivating over Trump every morning, waking up. They probably have, you know, like the Mark Elias guys out there. They've got the Donald Trump chew toys for their dogs and stuff. They kind of go wild with it. So he's sitting there, every single Trump truth, he's like, oh, this one's the one. Oh, this one's the one. Oh, this one's the one for my protective order. They're just waiting for it. What's Trump going to say that we can use to shut him up? And then booms, he drops this one. If you go after me, I'm coming after you, which has been just, I think, a truth that we've been talking about here for a long time. I mean, it'd be like psycho if he didn't do that. If the DOJ is going to be weaponized and used against political opponents, that's the whole point of the game, is to capture the flag, become the king of the castle. So then you can use the DOJ to go after your political opponents. It's like obvious. If we're going to go into a banana republic, third world dictatorship type of structure, this is how it's going to go. I mean, this is what we want. And I'd rather have our guy in there, you know, going against these people, because at least it's not them. This is how it's going to go. And so they're upset about it. And like, hey guys, this is what you caused all of this. Hello. They say if Trump were to begin issuing public posts using details, for example, of grand jury transcripts, which I would love to see, so we could see how the whole indictment was corruptly executed in the first place. And they really don't want us to see that at all. For example, if Trump, it's like a dream come true. Trump just starts posting the transcripts and all the discovery. Hey, this one, this one, this one. He said this, here's what they say. It could have a harmful, chilling effect on witnesses, right? So remember, when we were going back to those scales, what do they say? Relative to Trump's free speech, they say, no, it's a chilling effect. It could have a harmful, chilling effect. Could be a very big problem for other witnesses, or it could adversely affect the fair administration of justice, meaning that Trump needs to be shut up, and all of these other issues, free speech, political speech, his right to his defense, his right to criticize the prosecutorial agencies that are going after him because of his status as a candidate, all should go out the window, because it might theoretically impact adversely the administration of justice. Well, look, nobody thinks you guys are administering really anything. You are prosecuting, executing, and nobody thinks this is justice either. So you call it justice, half the country calls it injustice, and they want him to not speak about it. They say the government's proposed order provides provides that either party can seek to modify this at any time, meaning that Trump is in a better position now. This is actually good for Trump. If he receives discovery now rather than getting no discovery at all. So he actually is so dumb. His defense is so dumb that they don't know that this order is good for them, because, Judge, if you grant it, then we can show up and just dump this all on their front yard. And then they can't do anything with it because you granted our order, not theirs. If the court issues the government's proposed order without awaiting a responsive brief from Trump, Trump will be free to review the discovery that the government will promptly produce, and they can seek any modifications that they want. And once in possession of this detailed discovery, then Trump's going to be in a better position to assess and justify whether to seek a modification of the order at all. Molly Gaston. She's acting like she's doing a big favor for all of us. Oh no, they're so stupid over there at the defense attorney's offices that they don't even know how good this is for them. And as soon as you grant exactly what we want, Judge, that limits them, then we'll just go ahead and dump it on their doorstep. Disgusting motion that they would even file that. And the judge wouldn't go that far to actually grant it, but here was the text, grant it without Trump's response. Trump and his team did respond, but here is the actual order that the government is proposing. 5 pages. They say this is what Trump should be limited. This order does not apply to records that are publicly available independent of the government. Okay, great. All materials provided by the government, by Biden and Mayor, shall be subject to this order and may only be used solely in connection with the defense of this case for no other purpose without further order of this court. So a True Social post, they'll say, is not in connection with this case. They want Trump and Trump's lawyer to not disclose the materials to anybody other than people working with the defense. Trump and his lawyers shall not copy or reproduce the materials in any way. They shall not disclose notes or records to anybody other than if you're involved in the case, if you're a witness, defense counsel, expert witness, any of those things. After the conclusion of this case, the materials shall be destroyed. All materials after this case is over, after they put Trump through a fake sham show trial, shall be destroyed. Everything goes back to the United States. Gone. The restrictions set forth in this order do not apply to documents that are part of the public record. Here are the sensitive materials. Materials containing personally identifying information, which is very broad, right? I would say, how about we get all of that redacted? Sure, like we won't release any materials containing PII with the PII. We'll redact all the PII and then the information contained therein. We're free to do with whatever we want. We're the defense. Rule 6, materials. Grand jury subpoenas, witness testimony, and exhibits. This stuff is critical. We would love to see this. In some criminal cases, remember, people are charged through a criminal complaint. And when we go through criminal complaint cases, we often will see an FBI agent says, I'm Special Agent so-and-so. They draft it up and they filed the criminal complaint, almost like getting a ticket. The grand jury is another way to bring criminal charges against somebody. And it's like a miniature trial that only happens with the government. There's a presentation that takes place there. And we want to see who testified and what the exhibits are and what was said. They don't want Trump to release any of it. Materials obtained through sealed search warrants, again, and sealed orders obtained by the government's filter team. They don't want recordings, transcripts, or any exhibits related to witness interviews or materials that came from other governmental entities. All silence. And so let's say, for example, Trump and his people, they file a records request or they file a demand for supplemental discovery and it goes over to, Federal Elections Commission or something like that. And the Federal Election Commission returns some documents back and the documents implicate some problems in the election or something, right? Trump's going to say, I got to show everybody that stuff. I need to bring that out to everybody's attention. They don't want that to happen. They want all of this stuff sealed. The government shall indicate to Trump's lawyers in discovery whether these are called sensitive materials along with the disclosure. They say, unless the government grants permission, no sensitive materials may be disclosed to anybody other than Trump, Trump's lawyers, and people on the defense team. Look at this. So similarly, any sensitive materials must be maintained and in control of the lawyers. Lawyers may show sensitive materials to Trump as necessary to assist in the preparation of the defense, but the lawyers may not give Trump a copy of the document. No copies to Trump. And if the lawyers do show the sensitive materials to Trump, the lawyers may not allow Trump to write down any personally identifiable information. And if Trump does take notes, the lawyers must inspect Trump's notes. You must look at his notebook to ensure that Trump has not copied down the info. So empty out your pockets there, Donald. No, empty it out. Did you have any phone numbers written in there? The parties may include designated sensitive materials in any public filings. No party shall disclose unredacted sensitive materials in open court. Parties can modify this, and this is what they want the judge to sign. This is from Judge Tanya Chutkin, and this is the proposed order. Now, there was a back and forth on this. Trump's team has ultimately responded, but Trump's team originally asked for an extension. They said, oh my gosh, Judge, at 6 p.m. on a Friday, the government emailed its proposed order. They said it's basically take it or leave it. Then they filed this motion. That morning, the court entered a minute order saying that we have to respond by August 7th at 5 p.m. So they enter a motion in on a Friday. You say we've got by Monday at 5 to respond, and they just give you this motion? To make sure we've got time to prepare, we asked this court to give us 3 additional days to allow us to respond by the 10th. This is substantially less time, by the way, than is provided for in your local court rules. Your rules say 14 days to respond to motion. They file on Friday, we get 2 weeks, 14 days. And that will enable Trump to assess what's going on here. And also, a brief extension, by the way, would give us time to meaningfully confer. We don't need the court to get involved in this. Discovery is going to be extensive and complex. It's why we should be cooperative. Requiring a Monday response on a Friday evening forecloses the possibility of an agreement, and this encourages improper tactics by the government in the future, dropping Friday night motions. They say Trump is prepared to confer in good faith, but we want just 3 more days, Judge. That's it. Consistent with the local rules. The rules say 14 days. And if we can't agree after those additional days, then it would be appropriate to file and have a hearing on this. Pro hoc vice pending for Todd Blanche, Trump's lawyer, along with John Lauro, another one of Trump's lawyers. And then they submitted a bunch of the different exhibits. I think these are the emails. Thanks for the email suggesting a meet and confer at 6 p.m. on a Friday, though. That's not realistic. We're going to suggest that we brief these issues and request oral argument. Please note that we did not have adequate time to prefer. And so you can see the emails here. And again, all these documents are on the mind map, which you can sign up for at robertgovea.com if you'd like to read ahead further. But what ended up happening is the government opposed the motion for the extension of time. They said, you don't need any more time. And the judge ultimately agreed. And the judge issued an order where she said all of that was denied. She said, all right, nope, we're holding fast. 5 p.m., August 7th deadline. Says Trump shall file a response. The request for an extension is denied. If you've got a problem with the proposed order, let us know in your filing. And Trump's team submitted that filing. Here's what it looks like. 29 pages. Let's see what it says. From Donald Trump's team, they say this is the response to the request for a protective order. The rules say the court can't issue protective orders that limit discovery materials when there are particularized safety and security concerns. Instead of hewing to this narrow framework, the government requests the court strict all documents produced by the government, all of them, regardless of the sensitivity, contrary to the law and to Trump's First Amendment rights. To resolve this issue, Trump respectfully requests you adopt our red lines, our changes, which narrows the proposed order to shield only the genuinely sensitive materials from the public view. This more measured approach is consistent with other cases and balances the government's claim with expediting discovery with the rights of Donald Trump. We have the balancing test. Going quickly is not an interest to the defense unless the defense is interested in going quickly. Trump's team says additionally, the red lines, the changes to the order, resolve other issues, and to the extent that the court overrules Trump's objection to restricting the use of non-sensitive documents, we attach an alternative red line as well. So here are their arguments. They say the proposed order that the government dumped out is overbroad. In a trial about First Amendment rights, the government seeks to restrict those rights, and it does so against its administration's primary political opponent during an election season in which the administration, prominent party members, and media allies have literally campaigned on the indictment and proliferated its false allegations. Biden has also capitalized on the indictment, posting a thinly veiled reference to his administration's prosecution of President Trump just hours before the arraignment. And if Donald Trump can post stuff on Truth and Joe Biden can post stuff on Truth, oh, maybe he should be indicted. A cup of Joe never tasted better. And this was his bizarre dark roast meme. And if you play it, he takes a sip and it looks like he's about to keel over when he's trying to drink it. So they say that there was another article, and there's been other hints that Joe Biden wants to prosecute Trump. They said, indeed, President Biden promised from the outset that his administration would ensure Trump, quote, does not become the next president again. Said that November 9, 2022, does not become the next president again. The Biden DOJ also waited 2.5 years to seek this indictment. So against this backdrop, the government, Biden DOJ, requests that this court assume the role of a censor and impose content-based regulations on President Trump's political speech that would forbid him from publicly discussing or disclosing exposing all non-public documents produced by the government, including both purportedly sensitive materials and non-sensitive, potentially exculpatory documents that might show Trump is innocent. Even if they disclose this big batch of documents and Trump says, oh, perfect, here in this discovery, you think this is the key to your case? Well, I've got this other discovery in my document that totally shatters that. And so how about I can talk about both of these things? Trump's lawyer says this untargeted method offends both the First Amendment, which actually requires a compelling government interest that is narrowly tailored to justify it. But it also has problems with the First Amendment. It says the government's attempt to restrain Trump, if they want to do this, they must have a compelling reason for the restraint. Here, Trump does not contest the government's interest in restricting some of the documents it must produce. However, the need to protect that information does not require a blanket gag order over all documents produced by the government. Rather, the court can and should limit its protective order to genuinely sensitive materials, the least restrictive remedy possible. We should see as much of this case as we humanly can, and the government is seeking to limit it. Why? The government does not and cannot explain why this protocol would be insufficient. It can easily designate documents it thinks are sensitive. Apparently, it's already done that. And this district, the local rules, doesn't regularly prevent the disclosure of these types of documents. The court recognizes that a protective order should be limited to documents that implicate the safety of witnesses, dangers of perjury, witness intimidation, and information vital to national security. Nobody's arguing about any of that. But here, the government does not explain how the existence of some potentially sensitive materials are good cause for the closure of all non-public material it produces. Apparently, they've already identified stuff that is sensitive. And so accordingly, Trump asks you adopt our proposed order. They say Trump has not had much time to prepare this. Due to the extraordinarily limited time Trump has had to prepare this response, we have not been able to talk to them about this. The government declined a cooperative approach. They refused any real-time feedback about this. Just hours before our deadline, the government notified Trump's lawyers that it would oppose most of our revisions. Neat. Although time limitations prevent us from fully explicating every proposed edit, here are some of the changes. They want to change the definition of authorized persons, who's on the team, who's employed. Defense counsel may choose to bring on volunteer attorneys, paid employment arrangements, interns, and other things. So they propose this red line, right? Definition of sensitive materials, what is sensitive or not. The government declines without comment to conspicuously mark the documents it deems sensitive. They don't want to fight over it. They just want to call it sensitive and then not allow anything to get out. They talk about some of the procedures, and you can see we get near the end here into the conclusion. Signed off by John Lauro, Todd Blanche. They say without any reason to oppose sealing, the government has no reason to seal this stuff. And so please adopt our red lines, adopt our protective order. And they basically want the government to be much more narrowly tailored. You see this just one simple change here. Sensitive materials. They want it to go from old is all materials to now sensitive materials which are designated in accordance with paragraph 8. All right. Now the judge is going to come back out and she's going to issue some sort of order on this. You can see here the rest of the red lines. They just literally modified the government's order and they're making notes to the judge. The government said, we don't have any objections to this edit. That's the only one. They object to everything else. So they just object away. Here, the government has, okay, this one too, we got two now, A2, and this one, we got a couple things. They're okay with that change, but the rest of everything's got to go. So Judge Shutkin will be ultimately issuing a ruling on it. And of course, we'll see what that looks like and review the final order. But here is the author of the motion himself. This is John Lauro over on CNN, having this interview and this exchange with Dana Bash, talking about the Trump prosecution and the January 6th case.
This weekend, the judge rejected your request for 3 more days to consider the special counsel's proposed rules for how to handle evidence. The proposed protective order that would let Trump use some sensitive information, but not take that information with him. Will you agree to that?
Well, first of all, this protective order that's being suggested by the Biden administration is an effort to keep from the press important non-sensitive information that the Biden administration has that may speak to
This isn't by the Biden administration. This is by the
President
Special
Trump.
Independent Counsel.
And
no, it's not. No, it's not.
No, here for this reason, no. The independent counsel, it's not independent, it's special counsel.
And by the way, there's a New York Times article where Joe Biden says to Merrick Garland, stop clowning around and just do it already.
To get the approval of Merrick Garland in order to go forward. Joe Biden said in November 2022 that he wanted to see President Trump prosecuted and taken out of this race.
There's
so it
no,
is the Biden
I'm just going to stop you because there's no evidence
but the bottom line is
Joe Biden is involved in this, and you're right, it's a special counsel. Let's just stick to the question. Do you believe that this is something that you'll agree to?
Yeah, so the point is that we will not agree to keeping information that's not sensitive from the press. The press and the American people in a campaign season have a right to know what the evidence is in this case, provided that this evidence is not protected otherwise.
Right.
So we're going to oppose it, as we have. But for whatever reason, these lawyers on the prosecution team want to keep that from the press.
Well, won't the evidence come out in trial
candidly,
anyway?
That the press, some of it will, not all of it. I'm shocked that the press isn't lined up objecting to this protective order, because not only is President Trump being attacked for his First Amendment rights, now these prosecutors are trying to impinge on the freedom of the press.
Okay, let's stick to, I appreciate you trying to stick up
what's
for
happening. I'm telling you.
I appreciate you trying to stick up for us, but let's talk about the actual
I'm telling you what's going on right
substance
now.
of what they were trying to do in the filing, which was try to make the point not only that they want to keep the discovery information, what the witnesses said, for the time being quiet, but also he made pretty clear, the special counsel, that the idea that the former president is calling him deranged and mentally ill is something that maybe shouldn't be happening. So let me ask you, as his attorney in this criminal case, do you want your client to stop speaking publicly like this?
Nah.
Using terms like that?
This case was brought by the Biden administration in the middle of a political campaign, and with the realization that people are out there campaigning for office. I'm not involved in the campaign. I'm involved in representing
Totally understand.
Mr.
You're
Trump
not his campaign manager. You are his lawyer. As his lawyer, would you want a client to say things like this about the special counsel?
One thing that
he is a presidential candidate. One of the top issues in this country, a weaponized, partisan, politicized DOJ that is being used by Joe Biden in order to go after his political opponents. As a person who is campaigning, he has no choice but to talk about that. The fact that they made him a criminal defendant and the subject of that very issue, that's on them. That doesn't mean he has to be silenced now just because there's some overlap with the criminal case that Joe Biden brought. You're telling me that we want to live in a country where your political opponent can prosecute their opponent, prosecute you, and you can't even say anything about it. Not only can they prosecute you, but they can shut you up too. So they can raid your house, they can lock you up, they can detain you, and if you even challenge it, now you're talking about the case, and that's too harmful to the case. And if you run for the presidency, you can't talk about the thing they've done to you, lest you jeopardize the fair administration of justice.
One thing that we are going to do is fight this very, very unusual, outside of the bounds, criminal prosecution of First Amendment rights vigorously in court. My focus is on addressing the issues. One of the issues that the Biden administration will have to prove beyond a reasonable doubt is that Donald Trump had corrupt intent, had criminal intent when he protested the results of the 2020 election. That's core freedom of speech. That's core
let's talk about
speech,
this. You've talked about freedom of speech
under our Constitution.
You've talked about freedom of speech a lot. I want you to listen to what Donald Trump's own former Attorney General said about that argument.
Bill?
I really don't think that's a valid argument. He can say whatever he wants. He can even lie. He can even tell people that the election was stolen when he knew better. Free speech doesn't give you.
He just said that you can do that?
The right to engage in a fraudulent conspiracy.
Wait a minute. What? That's a weird set of clips. He almost is contradicting himself, no?
I really don't think that's a valid argument. He can say whatever he wants. He can even lie. He can even tell people that
he didn't even do that.
The election was stolen when he knew better. Free speech doesn't give you the right to engage in a fraudulent conspiracy.
But you need to know what that act is. That was a weird set of clips. I don't know why they clipped those. Almost 3 separate clips. Weird.
Your response?
Well, first of all, there was no fraudulent conspiracy. That's part of the reality of the defense. What President Trump was entitled to do and what Mr. Barr misses, and I'm not sure he's read all the cases, but when it comes to political speech, you can not only advocate for a position, but you can take action. You can petition. You can ask even your vice president to pause the vote for a period of time in order to allow the states to recertify.
But you can't break the law, which is what this indictment alleges.
What was it?
It alleges that he caused actions like approving fake. What
was it?
I'll tell you what the indictment says. The indictment says
Read it.
That he attempted to cause actions like approving fake electors, opening sham fraud investigations, and obstructing the certification of the election. Whether he can prove that, that's going to happen in the trial. I'm just saying what's in the indictment.
Yeah, but let's Right, and let me take the first thing, the question about electors, okay? Alternate electors are used in every 4-year cycles. The Senate parliamentarian acknowledged to Vice President Pence that they always receive protest alternate electors. None of those electors were counted. Vice President Pence was completely aware of the nature of the
They weren't
protest,
counted because Mike Pence rejected this scheme. That's why they weren't counted.
Absolutely, and that's how the political process works. But there was no defrauding, there was no trickery, there was no deceit, because
if Mike Pence had said yes, then that's exactly what would have happened.
No, because
if Mike Pence would have said yes, what would have happened, Dana? Would it have gone, Trump would have just been president, I guess, for another 4 years? That's not how it worked at all. I think they literally think Mike Pence would have just said, Daddy's in charge, Big Mike's here, Trump's the president, tear up all the electoral votes or something like that.
It's only one.
Because thankfully with freedom of the press, you
have to
let me finish though, because, no, but you asked me a question and I hope you can let me finish, because the government alleges deceit or trickery, and all of this played out in the open. It's all free speech. There was a Supreme Court decision, Hammerschmidt, which is right on point, that says when you're exercising free speech, you're not engaging in a fraud on the government. And that's what, unfortunately, most people don't understand.
That's just one example of the actions. That's just one example of the actions in this indictment.
But you're entitled.
And this is a long list.
What is that? Her notes? Are those her CNN producer notes? What does that say? Oh. They typed up bullet points for these bonehead anchors. Look, oh my gosh, they typed up bullet points. It says list of all actions, something Trump on something, okay? And it's like bullet points. It looks like Joe Biden's note cards. Hey, you sit here. All right, when Trump's lawyer comes on here, just run down this list of all the actions that he took. I would love to read that, because I'm gonna guess a lot of those say Trump called and asked, Trump questioned, or Trump, inquired, or Trump did something, or Trump spoke about it, whatever it is. It's all speech, all protected behavior. And so she's got a nice
long list that we've compiled from the indictment. I mean, it's more than a dozen actions that the former president allegedly took.
Post it.
Where do I even start?
Tell me.
Asking the Arizona speaker to interfere with ascertaining Arizona's electors. The Justice Department to conduct
a speech.
Read the next one.
But any alleged
is speech.
But any alleged, almost all of.
Oh, he's laughing too. Okay, so Dana, look, she goes to read a second one and she shuts up. He busted her so badly. We couldn't even see what that was, what's on the list. But he says to her, give me one. She reads one, asking the Arizona Senate Rusty Bowers. He goes, read me another one. Watch, she starts to read the next one and then he cuts her off, or she stops herself because it probably says ask.
Pertaining Arizona's electors. The Justice Department to conduct
a speech.
Oh!
But any alleged
is speech.
But any alleged almost all alleged criminal activity has to do with using words and his speech. And that's listen.
What you don't
this is obviously the defense that you're going to use, and it will be fascinating to see how it works out in a court of law. I want to move on to another issue.
I got to tell you though, but you make an interesting point, because you're saying that asking is action. No, asking is aspirational. Asking is not action. It's core free speech. The press should be defending free speech in this case.
Let's talk about something else that you've repeatedly said.
No, we don't want to protect free speech. We hate Trump and we just want him gone. So good, man. Hey, Dana, post your notes on Twitter. Drop those things on Twitter so we can see them, all right? Hey, our mind map's available, robertgovea.com. You can go see all my notes. They're all right here. robertgovea.com, you can see everything. But for some reason, they don't want us to see anything. They don't want us to see the evidence of this case. They don't want Trump to talk about it. They want him silenced. They want all of us silenced and censored so that they can continue to prosecute their political enemies under the dark of night without anybody exposing their partisan corrupt hackery. But of course, we will do that as we shine our spotlight here, my friends. Thank you for subscribing and following along as we continue to cover this case. We'll see you as it evolves.